Today, we're going to delve into an issue that is of vital importance in our field: sanction regimes. This topic often presents a complex legal challenge, as it involves a delicate balance between protecting individual rights and maintaining public order. To begin, it is important to note that Russia's invasion of Ukraine in February 2022 led to the adoption of several packages of restrictive measures by the European Union. These measures are unprecedented in their scope, diversity, and novelty, even involving Belarus in the sanctions regime. This has an immediate impact on the workload of the European General Court, which now has more than 80 direct appeals against these measures. It appears few compared to the number of individuals listed, but it is historically enormous for the General Court. Let's consider the legal issues surrounding these restrictive measures. One of the key issues is the balance between the state of law and the need for maintaining public order. How do we ensure that these measures are not infringing on basic human rights of the individuals and also listed entities? This is a question that is often at the heart of legal debates about restrictive measures. Firstly, there are procedural challenges. For example, for the first time with regard to these measures, we are seeing actions for damages accompanying actions for annulment. This testifies to the tenacity of applicants who no longer consider the simple annulment of sanctions as a sufficient outcome to their appeals. In addition, a relatively high number of applications for a stay of execution have been lodged. But beyond the procedural issues, the real challenge is the judicial review of the restrictive measures on their merits. In other words, how will the General Court examine the legitimacy, proportionality, and effectiveness of these measures? The judges are faced with complex legal issues and unavoidable political stakes. This is an unprecedented situation that has the potential to make the existing legal framework even more complex. In short, these new cases before the CJU will not only raise unprecedented legal issues, but will also rekindle long-standing tensions over the judicial review of restrictive measures. The future of case law in this area is therefore uncertain, and it is crucial for lawyers, politicians, and society in general to keep a close eye on developments in this area. Go in details. In front of the General Court, the legal debate is complex, but we can observe a range of the legal issues which come on the table for the sanctions applied against Russia. First, the question of legality of the criteria created to put individuals on the list. Second, are the restrictive measures being applied in a proportional manner? Third, were the measures applied on the basis of a manifest error of assessment of the facts? Also, are they the least restrictive means available to achieve the objectives of the restrictive measures? These are questions that need to be answered to ensure that the measures are not only effective but also fair. What are those current criteria? They were created by the EU Regulation 2022/330 of 25 February 2022. They are 7. A. Be responsible for supporting or implementing actions or policies which undermine or threaten the territorial integrity, sovereignty, and independence of Ukraine, or stability or security in Ukraine, or which obstruct the work of international organizations in Ukraine. B. To support, materially or financially, actions which undermine or threaten the territorial integrity of Ukraine. C. Legal persons, entities, or bodies in Crimea or Sevastopol whose ownership has been transferred contrary to Ukrainian law, or which have benefited from such a transfer. D. To support, materially or financially, or benefiting from Russian decision-makers responsible for the annexation of Crimea or the destabilization of Ukraine. E. To conduct transactions with the separatist groups in the Donbas region of Ukraine. F. To support, materially or financially, or benefiting from the government of the Russian Federation, or, and the last one, G. Leading businesspersons or legal entities involved in economic sectors, providing a substantial source of revenue to the government of the Russian Federation. Now, let's my partner go in deep on the topic of the day, the question of the legality of the criteria themselves.
Thank you, Clarice, for this presentation. Let's go to the question of the legality of the criteria. Sure, the wording of those criteria could be legally discussed. Do those criteria respect the values of the rule of law? Do they respect the principles of foreseeability of union acts? It is very important to understand that measures to freeze funds taken against a listed person or entity on the basis of those criteria constitute only preventive administrative measures. In the Council's view, the restrictive measures against Russia are intended to put pressure on the government of the Russian Federation to put an end to the invasion of Ukraine. By their precautionary nature and their preventive purpose, these measures differ in particular from criminal sanctions. The fact remains, however, that such measures seriously affect the rights and freedoms of the persons or entities concerned.
I totally agree, Frederick. Those criteria can be viewed in the light of the potential infringements of the fundamental rights of the persons or entities listed. In order to delimit the scope of the Council's discretionary power, that judicial control of the exercise of that power is managed on two sides. First, the general rules defining the legal conditions for the adoption of restrictive measures such as those set out by the criteria, and second, the adoption, on the basis of an individual examination, of decisions to freeze funds in respect of specific persons and entities. As regards the general and abstract definition of the legal criteria, it is consistently recalled that the European Council has a broad discretion. The general rules defining those criteria are subject to limited judicial control, but the restriction of that control does not have the effect of preventing it. In the context of the sanctions applied to Russia, this judicial control takes on a particular dimension because of the unprecedented nature of the number of sanctions adopted against Russia and the historic number of persons included on the list, which is incomparable with the 39 other sanctions regimes currently in force. This context means that the exercise of judicial review of the definition of the general criteria must be understood in a broader context than that adopted for the other sanctions regimes currently in force.
For sure, Clarice. Let's go on one example of challenging the legality. Everybody knows the principle of legal certainty. This is a general principle of union law, requires in particular that rules of law be clear, precise, and foreseeable in their effects, in particular, where they may have adverse consequences for individuals and undertakings. For example, what really mean financial support to Russian decision-makers? To what the notion of Russian decision-makers clearly refer to? Without establishing a list of persons who belong to this group. Exclusively Mr. Vladimir Putin and the members of his government. Or a wider circle of people, including the members of the Duma. Or other alternative, an even wider group of people. With this vague wording, the Council can therefore impose sanctions in an arbitrary manner, without people being able, reasonably and unambiguously, to understand and identify the decision-maker in question. Without specifying the group of persons referred to as Russian decision-makers, no one can clearly identify who is directly responsible in the political sense of the term, for the annexation of Crimea or the destabilization of Ukraine. You see, nothing is obvious, and this raises real legal questions.
Thank you, Frederick. In conclusion, restrictive measures pose a range of legal issues that the listed individuals or entities need to understand and navigate. They challenge them as to balance individual rights with collective security, and to ensure that these measures are fair, proportional, and effectively enforced. Let's continue to explore this topic in detail on the next video by a presentation of the recent case law published by the General Court beginning of September 2023. See you soon and have a great day.